a check-into cash location in Chicago. The company's non-compete agreement applies to any similar business within 15 miles of one of its stores. Lyndon French for The New York Times. The clerks at Check-into Cash, a national chain that offers check cashing and payday loans, or paid close to minimum wage to do tasks like enter customers' information into a computer. The job does not require much training. Some employees lack a high school diploma. Nevertheless, many must sign a contract that prohibits them from working at competing companies. Legislation to restrict or ban these so-called non-compete agreements has been enacted in several states, but the contracts remain widespread even among low-wage workers. Attorneys general are also now getting involved, adding legal muscle to the political and economic debate. On Wednesday, the Illinois Attorney General sued Check-into Cash, accusing the company of violating a state law prohibiting non-compete agreements for workers making less than $13 an hour. The lawsuit, the first since the law was passed last year, demands that the company remove the clause. Check-into Cash has about 250 employees in Illinois and about 3,000 nationwide. "I want to ensure that Illinois workers have the freedom to change jobs and seek better wages," said the Illinois Attorney General, Lisa Madigan, a Democrat. "And what we have found is that the use of unfair non-compete agreements have scared a lot of low-income workers into staying in low-paying jobs when they could, based on their experience, get better pay." Check-into Cash did not return several calls seeking comment. Companies have used non-compete agreements for decades, but employment lawyers say that until fairly recently they were limited to executives and professionals like research scientists and engineers. Today they extend up and down the wage ladder. About 1 in 5 employees was bound by a non-compete clause in 2014, according to a survey by economists including Evan Starr, a management professor at the University of Maryland. When a worker violates one of these agreements, courts can prevent them from taking a new position or remove them from a job they've settled into. Even when that does not happen, the threat creates a chilling effect that makes people skittish about leaving or seeking a raise. Volumes of economic research have identified the proliferation of these agreements as one reason American wages have been stagnant. This has led to a push from state and national politicians to limit where and how they can be used. Last year, the Treasury Department and President Barack Obama's Council of Economic Advisers released papers on the economic harm wrought by non-competes and other restrictive employment contracts. In 2015, Senator Al Franken, Democrat of Minnesota, introduced federal legislation to ban non-competes for workers making less than $15 an hour. The bill never passed, but last year the Illinois legislature passed a law prohibiting non-competes for employees who make less than $13 an hour. Since then the Attorney General has reached settlements with several companies to have the clauses removed, but until Wednesday had not filed a lawsuit. In addition to alleging that Check-into Cash broke Illinois' new non-compete law, the suit takes a page from the economic literature by arguing that non-competes hurt the state's economy by suppressing wages and preventing workers from leaving for better pay. It also argues that non-competes make it harder for state employers to find the best people, reducing innovation and limiting the pool of workers that thriving businesses need to grow. "It's clearly a winning issue for attorneys general," said Alan B. Kruger, a Princeton economics professor who was chairman of Mr. Obama's Council of Economic Advisers. In Illinois and elsewhere, much of the recent interest among legislators and attorneys general began a little over 3 years ago, when the Huffington Post reported that the Jimmy John's sandwich chain required hourly sandwich makers and delivery drivers to sign non-competes. Illinois sued Jimmy John's last year, arguing that its non-compete agreement violated the state's Consumer Fraud Act. The new non-compete law hadn't been passed yet, and reached a settlement in which the company agreed to remove the clause. New York's Attorney General announced a similar settlement with Jimmy John's. Each time the Jimmy John's case was in the news, the Illinois Attorney General's office received a round of calls from workers who felt they had signed an unfair non-compete agreement, including nurses, sales representatives, daycare workers and cooks. One complaint came from an undisclosed employee of Check-into Cash. Ms. Madigan said her office was investigating about a dozen companies over the use of non-compete agreements. According to the lawsuit, clerks at Illinois branches of Check Into Cash agree not to work at any employer offering services like check cashing, loans or money transmission for a year after they leave. It applies to employers within 15 miles of any of the company's more than 1,000 locations in the United States. The Illinois Attorney General's lawsuit said that because Check Into Cash had 33 locations in the state, its workers were effectively agreeing not to seek employment at competitors across Chicago and its suburbs. And the language is broad enough to extend far beyond other check cashing and payday loan companies, for instance, to include department stores, which offer their own credit cards, and the post office, which allows people to send money, said Jane Flanagan, an assistant attorney general in Illinois, who is the lead lawyer on the case. Studies have shown that many employees who sign non-compete provisions have no idea what they've agreed to. People aren't necessarily aware they sign one of these and then they try to leave, and at that point their manager tells them, "Oh, but you have this non-compete," Ms. Flanagan said.